Be ready. 5 seconds. Start. In response to the above tender notice, the appellant also submitted a tender offering to undertake the work at the 50% above the schedule of rates stop. This offer was accepted by the respondent corporation with a direction to the district manager FCI Hisar that no amount towards security be demanded from the appellant as the security amount of rupees 3,09,500 stood deposited in the regional office stop. Shortly after the allotment of the contract to the appellant sent a fax message expressing his inability to undertake the handling and transport contract and withdrawing the offer made by him stop. By this time, the appellant had already executed a formal agreement with the respondent corporation on 28th May 2001 stop. In response, the respondent corporation informed the appellant that any withdrawal after the execution of the formal agreement was tantamount to a breach of the terms and conditions of the contract and would attract action under clause 10b of the agreement stop. The appellant was requested to take up the handling and transport work within 1 week positively, failing which the respondent corporation proposed to take recourse to clause 10b of the agreement to get the work done at the risk and cost of the appellant. Para. It is common ground that the appellant did not undertake the work stop. He cited some security problems which, according to the appellant, prevented him from discharging his contractual obligations stop. Not only that, the appellant demanded the refund of rupees 10 lakhs which stood deposited with the respondent corporation pursuant to the direction issued by the High Court in the writ petition referred to earlier stop. Upon refusal of the respondent corporation to refund the amount in question, the appellant filed writ petition number 2416 of 2002 in the High Court of Punjab and Haryana for a mandamus directing the respondent corporation to refund the same. Para. The High Court dismissed the said petition, holding that since the parties had entered into a written contract, their mutual rights and obligations were governed by the terms and conditions of the said contract stop. The High Court observed it appears from the record of the case and in particular Annexure P5 dated 20 June 2001 addressed to the petitioner by the FCI that the petitioner had executed agreement in the office on 28 May 2001 and his offer at 50% ASOR was accepted by the office wide telegram dated 25 May 2001, a copy whereof was sent to the petitioner through registered post stop. It has been clearly mentioned in Annexure P5 that the FCI had accepted the offer of the petitioner and that, being so, in our view, a concluded contract had come into existence stop. Withdrawal of offer would certainly attract relevant condition of the contract stop. The contract that has been arrived at between the parties has not been placed on records stop. The terms of contract in the event a party after its offer has been accepted may back out are thus not known stop. There is, however, sufficient indication forthcoming from Annexure P5 that clause 10b would apply in the event of contractor may not carry out the work allotted to him. Stop. This clause too has not been shown to us nor made a part of pleadings. Stop. All that we would thus like to observe at this stage is that once the parties have arrived at concluded contract, the terms thereof would alone determine the rights inter se parties. Stop. Be that as it may, petitioner cannot ask for refund of rupees 10 lakhs on the dint of orders passed in his earlier petition bearing number 1368 of 2000, as it is only in the event work was not to be allotted to him that he could ask for refund of the money deposited by him. Stop.